Thank you, Larry. I assume I'm mic'd up. Um, Let me start by drawing two distinctions between this panel and the immediately prior panel, preceding panel. First of all, instead of focusing on what Congress did wrong and how it might be changed, we are basically going to, this panel, its underlying premise is we're going to have to live with the world as it is for as long as we can see, frankly. So irrespective of how my panel members may feel about the likelihood of imminent congressional action in the tax area, the underlying assumption of this panel is that we're going to have to deal with the rules as they are. Secondly, the other distinction which struck me in listening to the first panel is we're not going to be focusing so much on what Congress did as on what it didn't do. The TCJA, to my knowledge, has only one extremely oblique reference to the existence of international tax conventions. That's in the reference to the prior version of Section 163J. If someone knows of another reference to the treaties, I would be most interested. The treaties, of course, I know it's always a surprise for Congress to learn it, but they are the supreme law of the land, you know. And I think some people take that fairly seriously. And so this has been a hard panel to organize because instead of doing it by section, we're going to do this sort of conceptually. And there are, at least to my knowledge, 4 aspects of the TCJA that raise treaty questions. There's the limitation on the foreign tax credit in GILTI. There's the discriminatory aspects of FDII, which are not available to foreign corporations. There's several aspects of the base erosion anti-abuse tax, which raise treaty issues. And there's the fact that all of our treaties, or virtually all of them, grant a first-tier deemed paid foreign tax credit independent of the code. And now that 902 has been abolished, how does that stand? And some people, as I'm sure most of you know, have cited, they wave the banner of later in time, that solves everything. A couple of us are not so sure it solves everything. So we're going to organize this with Kim Major starting, talking to us about the BEAT, which I think is probably the most urgent of the treaty issues. I did a little article on this, which is in your supplementary materials. And by the way, in your supplementary materials, there's a section with all sorts of statutory and treaty references because in some respects, the language is important. So Kim is going to deal with the BEAT, and then we're going to deal with Mary is going to talk about the question of later in time, Senate Report 100-445, and also 7852D, and what is a conflict, which seems to be a question that no one has really quite addressed. And then finally, we thought it would be interesting to edge into the retaliatory provisions in the code, which have been around as long as any of us have been practicing, and see how they fare under treaties, and that assignment goes to Chris Bowers. So without further ado, Kim, you take it from there. You've got the clicker, so you can
I do have the clicker. All right, so as Professor Rosenblum was saying, we're going to tackle just BEAT. I mean, there are several aspects of the TCJA that we could have talked about, but that would take all afternoon, and we don't have it. So we're going to start with the BEAT. But you know, the initial issue, really, when you're trying to figure out whether something is violative of the treaty is whether or not the treaty actually covers it, whether it's a covered tax under the treaty. So we're going to start there. And for these purposes, for the treaty discussion, what we've done is we've pulled out the U.S. model. Of course, you know, U.S. model is just a model, but in any case, it's something to focus on, right? So when we start with Article 2, which is this, you know, a covered tax or not, there are a couple of aspects of Article 2 that you deal with, right? So first is whether this is an income tax, you know, under the code, with respect to is it an existing tax at the point that the treaty is signed up, and with reference to the later in time types of taxes that come after the signature of the treaty, is this kind of the same or substantially similar to those existing taxes? So honestly, when we're talking about the BEAT, and when we're talking about tax treaties in general, right? You really think about this as an income tax, and we have had this discussion, kind of earlier on in our prep sessions. Is the BEAT really an income tax? And as a general matter, the people go, yeah, I think I got a couple of arguments. Yes, it is an income tax. Now, there are aspects of the BEAT, particularly with respect to the disallowance of credits, that I know a lot of my clients would argue with, because they're looking at BEAT liability that is significantly driven by credits as opposed to modified taxable income. So they're like, I don't know so much that credits equals income, but in any case, putting that all aside, we do think that this is actually a little bit of a simpler issue than is this an income tax. In particular, because when it comes right down to it, as much as 901 is kind of fun, to use Ron's word, fun to talk about, it's not necessarily relevant in this context, right? Because what they look at is, well, what happens under the code? And despite the fact that Section 26 would pull the BEAT out of the definition of regular tax liability, still the BEAT sits in Subtitle A, right? And Subtitle A covers income taxes under the code. And so if it were an existing tax at the point that a treaty was signed up, then bam, there you go. That's not even really a question. In terms of what happens with respect to the pre-existing treaties, if you think about it, right, I mean, the BEAT was kind of an approximate substitute for AMT when AMT got repealed. And AMT, as a general matter, has been seen as a covered tax under treaties. So I think, as much as we would love to talk about whether this is an income tax or not, we're probably not really going to, right? Because it will be a covered tax, we believe, under Article 2. So then the next question, and I think this is the main, one of the two main questions when you're talking about treaty challenges, well, assuming that it is a covered tax, well, what happens with respect to this foreign tax credit? I mean, as I just alluded to, right? There are a lot of clients who say, look, my BEAT liability is driven by the disallowance of credits, including the foreign tax credit. And as we know, we're supposed to be allowed a foreign tax credit to some extent. And so, in my mind, this really comes down to the question as to how you look at the foreign tax credit, quote unquote, availability, right? And I do think that this is addressed not only in Professor Rosenblum's article, there's a competing article as well that discusses the other side. So we're gonna take a look at both of those arguments, because it's not necessarily clear to me which one of these arguments really kind of plays out in the law. I mean, I know sentimentally which one I bet on. I would never bet against Professor Rosenblum, but let's just go through them. So the first one is, if you look in the foreign tax credit on a standalone basis, right, you look at the structure of it, and as you know, what BEAT does is it takes really, it's an addition to tax. So you have your normal tax liability, and you look and you say, well, there's a benchmark tax, there's the minimum tax that BEAT says that you have to have paid, and if you figure out what your baseline is in on the statutory basis, which is determined under Section 59 Cap A. And whatever that excess is the amount that you have to write a check for to the government. But if you look at the math, right, and I know this is just a little bit of level setting, but this surprised a lot of folks. If you look at the math, so you have modified taxable income as kind of your top line, times the BEAT rate, and let's just call that 10%. And it's that increment between that and the baseline that is the issue. The baseline is your regular tax liability minus your specified credits. And these specified credits, we're talking about foreign tax credits, but eventually, kind of in the course of time, it's going to include all credits, right? I mean, your things like R&E credits are eventually going to fall away. And so, if you look and you're trying to figure out your BEAT planning situation, how do I mitigate my BEAT liability? If you succeed in taking things out of base erosion payment, you're going to take, you're going to preserve the value of the deductions, but you're going to affect that top line by 10%, so 10 cents on every dollar. If instead you're looking at your specified credits, which, let's just assume for these purposes you're not going to be able to do anything about. You've written a check to the government for them, and they're going to come off the bottom line. On a dollar-for-dollar basis, it's going to toggle that bottom line. It's going to move that, right, lower, so that when it comes right down to it, and this goes back down to my, is this really an income tax, which again is kind of an irrelevant issue, this really ends up being a significant driver of the tax. But here, if you just look at the statute on a standalone basis, you are denied a foreign tax credit. And yes, if you look at the model treaty language, if you look at the language of our treaties, our live treaties, it talks about the allowance of a foreign tax credit within the specified limitations, right? So it takes into account 904, et cetera. But a limitation is not the same thing as a disallowance. And this is a flat out disallowance, right? I mean, you compare and contrast, the right-hand side of the screen is the AMT. Now the AMT is kind of, effectively it's a parallel universe to the normal tax liability, right? And so they take away the regular foreign tax credits. They substitute a foreign tax credit that is a limited version of it. And so there is an allowance of foreign tax credits in the AMT that simply doesn't exist in the BEAT. And so on a standalone basis, you look and think, well, there's a pretty good argument, at least from this approach, that it's violative of the treaty because it doesn't allow any foreign tax credits. But on the other hand, right, and this is the argument that is presented kind of in the second article in your materials, there is some thought to, do you have to kind of look at all in? Because as we said, you have this regular tax liability. BEAT is an addition to that regular tax liability. So what happens? You are, in fact, allowed a foreign tax credit. That's what we're all moving towards, right? When you're trying to figure out your regular tax liability. And then the BEAT comes in on like kind of a top-line basis, and it claws back some of that foreign tax credit, but the clawback isn't enough to take it all the way down to zero, right? It's just not. And so here we have a very super simple example. We assume nothing except that whatever is going on with your regular tax liability, look at your incremental $100. The incremental $100, if it is all foreign source income, and if it was 21% foreign taxed, all of which would be creditable, what happens, right? So on your regular tax liability calculation, you get your 21% credits. And then your modified taxable income, let's assume that all $100 comes into modified taxable income, because it does, right? Your 10% BEAT rate applies. You have a $10 BEAT liability, right? With absolutely nothing else. You look and you go, well, on that incremental $100, you were already allowed the $21 credit. You claw back $10 of BEAT liability. You are still left with, on an all-in basis, $11 of credit, aren't you? And so that is kind of the all-in view that if you were to kind of go back and forth, yeah, you can see, all right, maybe this does allow some credit, and maybe you can say that that is in conformance with the treaty. Now then the question is, well, which one is the right one to take? Which view do you have to take? I mean, do you take the BEAT and you say it's an addition to tax, so you don't have to look at it on a standalone basis when you're testing it under the treaty? I mean, the AMT, and there is, a little bit of case law with respect to the AMT, that's looked at as a separate tax, but then it is kind of a separate tax, right? It's the parallel universe tax. So I don't know that there's necessarily an answer to that, but those are your two views that if you're reading back through those articles, this is the way they come to these arguments. But in any case, all right, so the next question is whether BEAT violates the non-discrimination provisions of the treaty. And here, whether you're in or out is a little bit of an easier issue because the non-discrimination provisions are a little bit broader. So they apply to all taxes of every kind and description. So you're not really limited to taxes under the code or income taxes, et cetera. Okay, so looking at this, we've just illustrated kind of the three relevant, and some are more relevant than others, but the three relevant portions of the non-discrimination provisions that we think are kind of implicated by the BEAT. So first is paragraph 5, right? And paragraph 5 is the other or more burdensome tax or requirement. And here, as you can see, what you're looking at is you're comparing the case where you have a U.S. subsidiary that is foreign-owned versus U.S. subsidiary that is U.S.-owned. And I think, you know, when the BEAT first came out, we all had the view, kind of the impression that this is really an anti-inbound type of provision. So we're like, you know, foreign-based multinationals, too bad for them, right? And if that were the case, which it is not, as we know now, if that were the case, then this non-discrimination provision, like paragraph 5, would be an issue. But as we know, and if you are, you know, part of a U.S.-based multinational, you know very well that is not the case, because, you know, CFCs could very well sell or get checked or whatnot, but bring assets, just as an example, bring assets into the United States that would be depreciable or amortizable, and, you know, you'd have a BEAT problem. So this one kind of falls away. The next issue then is paragraph 2, and paragraph 2 focuses on the taxation of the permanent establishment. So what you're looking at is a foreign parent with a permanent establishment versus what happens with a U.S. subsidiary and the taxation thereof. But as we know too, expenses that are allocated to the permanent establishment are going to be caught under the BEAT to the same extent that expenses that are accrued by a U.S. subsidiary that is making kind of the cross-border payments would be caught. So here too we have a parity that makes us, that makes this kind of fall away. Now, under the proposed regulations, you also get parity on the other end, kind of the recipient end. I'm not necessarily sure that this is relevant because this is not really a taxation of the permanent establishment issue, but again, you've got the ECI exception that has come in, so now you have parity on both sides of a payment. The most interesting part, I think, is paragraph 4. And so paragraph 4 really looks at what happens to the deduction of a U.S. subsidiary or someone who is in the United States that's making a payment that would be deductible, and who's on the other end of the payment. And so here you have a comparison of a payment made to a foreign subsidiary that is related versus a payment made to another U.S. sub. And this is where you do have a difference, because as we know, the BEAT is structured so that payments to U.S. subsidiaries, you know, simply not caught. Unlike the 163J scenario, where you have, you know, at least some thought that if you have a related tax-exempt entity, it's going to be caught. Here you don't have that kind of even a fig leaf, right? And as we know, there's a little bit of a difference between fig leaf and, you know, nakedness. So here you just kind of have the naked deduction, if you will, and it is caught. And so again, you have a little bit of an issue as to whether you're looking at, on a standalone basis, what is happening versus, you know, you're allowed under the regular tax liability calculation, you are allowed some of the deduction. So is some enough? Well, you know, query, it says, you know, you've got to be deductible under the same conditions, and query whether rate or effective rate is the same conditions. I would probably argue no on that. But I think that pretty much takes us through the you know, why do we care?
Thank you, Kim. Just one comment of my own on this. I realize that there are arguments on both sides on the BEAT, and we explored some of them. One of the problems I think that the defenders would have of the BEAT is that it's essentially quite an irrational tax. If you take an example, which is my favorite example, since I'm the chair, I'm going to indulge myself with this. If you take 100 of income and you have one expense, which is an interest payment of 90 to a foreign-related person, you have a normal tax base of 10, you pay 2.1 in your normal tax. If you restore that 90, you have a BEAT base of 100, you have 10 minus 2.1 for a BEAT liability of 7.9. That's the example I use in teaching. It's pretty simple to understand. If you add to that example of earning 100, that this same taxpayer has 100 million of foreign income fully covered by the foreign tax credit, then your beat liability gets to be a little bit more than 7.9. And I think that point demonstrates that what the beat is really after, not what with the TCJA in general, you can't go by what people said it was intended to do. You got to go by what it actually does. And it's really after the foreign tax credit. So leaving that, just the irrationality of the beat would weigh, it seems to me, in a court in arguing these treaty arguments. Mary, to you.
Well, thanks, David. I mean, one of the things that you ask yourself if you get into a situation like this is, well, why do we care? Because, hey, later in time, come on. And I think a lot of us over the years have been, I don't want to say brainwashed, but programmed to have that little mantra come into our minds. And so we thought we should take a look at that and see what it really means. And of course, first of all, we do have the Constitution, which, as David told us, says that legislation and statutes are both the supreme law of the land. Okay, supreme sounds good. What do you do if there's a conflict? And we have our own Supreme Court going back to at least the 19th century that has told us that if you have a statute and a treaty that are covering the same subject matter, that the courts will effectively do whatever they can to reconcile them so as to give effect to both. But if there is a conflict, if you cannot construe them to give effect to both, the later in time will prevail. Okay, so we know that that's the general guidance that we have on how to do this. It was fun for me to prepare for this panel in a sense, there's only so much fun you can get, but it brought me back to my very first to a few weeks of law school, which regrettably was not at this institution, but farther up the street. And before we started to learn anything really substantive in terms of law topics, they had us take a course on statutory construction, and that's all we did for a few weeks. And I got to relive some of that in going into the guidance on what you do when you're trying to read together a statute and a statute, or a statute and a treaty, or whatever, that appear to be in conflict. What should you look to try to reconcile them, as the Supreme Court has told us our courts must try to do? And of course, we have the ordinary meaning of the actual language, which different judges have different views on exactly whether you get beyond that at all. If you do get beyond that, you can look at things like statutory context. You can look at the canons of construction, the wonderful canons of construction, of which there are dozens, and point you in many different directions sometimes. You can look at the legislative history, and you can look at the evidence of the way a statute has been implemented to see what the executive branch thinks it means. Let's talk a little bit about canons of construction, because they're fantastic. And one of them is that a treaty, and this comes from the Cook case from the 1930s, a treaty will not be deemed to have been abrogated or modified by a later statute unless such purpose on the part of Congress has been clearly expressed. Fantastic. This was a great case about bootlegging, and after we had Prohibition come in, and Congress had passed a statute saying just how far offshore U.S. authorities could board foreign ships and search for, alcohol that might be on its way to the U.S. And they said of certain, I guess it was 4 leagues or whatever, which doesn't mean anything to me, I'm afraid. But at any rate, our partners around the world were unhappy with this, and the U.S. entered into treaties with, among others, Great Britain, and said, well, now you can only go an hour's worth of travel offshore. And so, and subsequent to that, Congress reenacted the initial statute. And so what happens when the U.S. boards a British ship, offshore, allowed by the statute but not allowed by the treaty. And the Supreme Court said, well, the fact that they enacted this statute subsequent to the treaty doesn't mean that the treaty disappears, that they didn't say anything about intending to override the treaty, so either in the statute or the legislative history, so the treaty limitation applied. So that's one thing. Repeals by implication are not favored. So if Congress doesn't say anything and query what that means, then you would tend as a judge to say, well, the treaty has not been overridden. Another great canon of construction is the specific controls the general. So if you have a specific provision and then a general provision, the specific could continue to govern the situation even if it has been later, the general provision has been introduced later, and query what that means in terms of interpreting particular statutes and, treaty relationships with particular countries. You know, how does that come into play? All of this gets more interesting when we look at the fact that in 1988, Congress enacted into the code section 7852D, where they claimed that what they were trying to do was to codify existing jurisprudence on the interaction between treaties and statutes. And what the statutory language says is that for purposes of determining the relationship, neither the treaty nor the statute shall have preferential status by reason of its being a treaty or a law. Seems pretty neutral. They indicated in the legislative history that they were particularly concerned by the interpretation that some people were giving to the Cook decision from the 1930s, that Congress was saying, we don't have to specifically mention that we're overriding a treaty in order to override a treaty. And also, God knows, you can't expect us, Congress people, to understand that there are treaties out there that, that have created obligations. You know, we can't be thinking about that all the time, so it would be unrealistic to expect us to have to mention that we're overriding a treaty. They also said that, you know, you have to think about whether a treaty provision, if it seems to be in conflict with the latest statute, is that giving the foreign country a bargain, a benefit that they didn't bargain for? And, you know, maybe it's creating cases where you're not fulfilling the goal of alleviating double taxation, for instance, but you're resulting in no taxation at all, and how could that possibly be the purpose of the treaty? So those kinds of things that you're supposed to think about. Well, one question that I've had, and had 30-some years ago when this statute was enacted, was did it accurately reflect the jurisprudence as it existed? Were they right to say that the Cook case was not saying that Congress had to explicitly say something about treaties if it wanted to override treaties in the case of a conflict? And I'm not sure that they were necessarily right about that. And, you know, we have yet to find out, actually, whether they were right about that. There is this quote from the Chu Hong case again from the 1880s, which I wonder if it read as sort of dripping with sarcasm in the 1880s as it does today. But I love this, the way they describe, say, aside from the duty imposed by the Constitution to respect treaty stipulations when they become the subject of judicial proceedings, the court cannot be unmindful of the fact that the honor of the government and people of the United States is involved in every inquiry whether rights secured by such stipulations shall be recognized and protected. And, I love this, it would be wanting in proper respect for the intelligence and patriotism of a coordinate department of the government were it to doubt for a moment that these considerations were present in the minds of its members when the legislation in question was enacted. So, you know, Congress, you you don't give yourself enough credit. Obviously, you're thinking about treaties all the time when you're legislating, and if you have some view on whether they're supposed to be overridden or not, you could have said it, and if you didn't, maybe you didn't. The only discussion, overt discussion of treaties that seemed to come up during the TCJA was in a hearing where Tom Bartold from Joint Committee was asked about the interaction with treaties, and particularly with respect to the BEAT, and as Tom said, well, it's structured as an alternative tax compared to the income tax. So I think our view is that there's not a treaty override inherent in that design. Like, what is that saying? You know, is that saying it's not an income tax, so we don't have a treaty issue at all? Or is it saying we don't think we're overriding treaties? Or what is it saying? We don't really know. Some commentators have suggested that the AMT limitation, which used to exist, is relevant to this question of particularly the limitation on the foreign tax credit under the BEAT. I personally don't think those cases are relevant at all, or they don't help us to resolve this issue. That was a case where Congress specifically, statutorily overrode treaties, pre-existing treaties, in order to create a limitation on the foreign tax credit. And I don't think one could suggest that because some treaties have been done since then that accepted this 10% haircut on the foreign tax credit for AMT purposes meant that those treaty countries were willy-nilly accepting any future limitation that Congress might want to put on the foreign tax credit. So if you go from a little 10% haircut to even conservatively viewed a 50% limitation on the foreign tax credit, is that a principle that our treaty partners have accepted? I wouldn't want to sit across from one of them and suggest to them that that's what they had done. David's article raised the interesting question, which I think is an interesting one, and it kind of brings us back to the specific controls the general issue of statutory interpretation. Could you read a silent statute, if you will, such as we have now, and pre-existing treaties and say, well, the treaties are specific because they're country-by-country bargains, and the statute is meant to apply generally, and maybe we could just read the statute to be modified by the specific treaty, and that would alleviate any potential conflict. I think that's what your argument was, pretty much.
Something like that, yes.
It's a great argument. We haven't seen it addressed, certainly in the last 30 plus years in the treaty, in the tax treaty statutory context. There was a reference to it in one of the AMT cases, and the tax court in that case said, well, we think that's an implausible interpretation, but that was completely dictum because they had a specific statutory override. And I think it's interesting, going back to the bootlegging case, that when the Supreme Court said that the UK treaty would prevail, they were effectively saying the same thing for 15 other treaties that the US had entered into with most of our relevant trading partners. So I would like to see that one come up in court someday. The last topic I just want to touch on is, do we care about 7852D at all? Is it even constitutional? Is it Congress's place to start to tell the courts what their approach to interpreting interactions between treaties and statutes are? You know, we can start with Marbury versus Madison to say that this is an essential function of the judiciary. And are we seeing a violation of the separation of powers if Congress comes in and starts to tell the judiciary, we're just going to codify the way that you should have been interpreting treaties, and we might be putting a finger in the scale of one canon of construction over another, but don't worry about it. This is just something that we can do in order to make you understand how we're legislating. And I would refer you to an article that's cited here that came out a decade ago, which goes through a very interesting analysis of that very question, and I certainly would be prepared to argue to a court that this is an unconstitutional statute, and if they want to, if anyone's telling them they should give any deference to it, they should just forget that. Thanks.
Thank you, Mary. I think the implicit question in all of this, which Mary didn't make explicit, but let me try, which is that later in time is designed to be a means of reconciling conflicts. But nobody seems to have ever thought real hard about what is a conflict, and that's the underlying question here. Is there really a conflict? You know, there are countries out there, Germany comes to mind, and there are probably others, that operate their treaties as exceptions to background general rules. I mean, for years, I think probably to this day, Germany gives a foreign tax credit by treaty, not by domestic law. So there is precedent in the world for having a general background statute. The other thing I'll say before turning it over to Chris is the BEAT is sort of a case by itself, but when you think about the fact that every single one of our treaties pretty much gives a deemed paid credit for the first year, and that you can easily envision situations under the TCJA where there are taxable distributions, actual distributions. For example, the exemption that was talked about in the earlier panel doesn't kick in for 1 year. And there's hybrid dividends. There's a number of possibilities of having an actual taxable dividend. What happens to the foreign tax credit if that comes from a treaty country? Are the treaties overridden? That's even hard. It seems to me that's an even harder question than the BEAT. In any event, Chris, to you.
David, one quick question that I've been thinking about as I've been following the reasoning and been very focused on the BEAT, and we could just kind of raise this, is why isn't the same reasoning maybe that you employed, for example, in the article, that says, well, there may be a problem with the BEAT in our treaties. Why isn't that same reasoning applicable to the 80% limitation on foreign tax credits for GILTI?
Well, I'm glad you asked that. I actually have an article in the works on precisely that.
I didn't even know it, guys.
I think the 80% limitation, first of all, my own view is that the 80% limitation on the foreign tax credit for GILTI is very generous. I mean, the reasoning, it seems to me, is that we're taxing this at what the Treasury has now interpreted it as a preferential rate. That's the only way I can interpret their allocation and apportionment rule, that they've converted the 50% deduction into a rate of 10.5 on GILTI income. Fine, I'm not troubled by that. I think that was sort of in the cards. But it seems to me that it flows from that you should give a 50% haircut to the foreign tax credit. Now, is that justifiable? I suspect that it is justifiable under this normal limitation to not give a credit for income that's exempt. So I'm not too troubled by the 80% limitation. We don't give a credit per the TCJA for exempt income, exempt dividends, QBI, distributions out of QBI. That seems to me to be justifiable. It's justifiable on common sense. And we can't totally exclude common sense from this area, right?
Sure.
Yeah. Okay. Chris is going to tell us that we're talking about common sense, though. We're now going to shift to the question. You know, Congress usually, I mean, if they think about it at all, they think about it belatedly, that there are other countries in the world, and they're doing things that we don't like.
Yeah.
So we've got these tools to go after them, and it seemed appropriate in this panel to discuss those.
And to David's point, we live in a dynamic world, and we've been talking about how BEAT could interfere with treaties and maybe violate non-discrimination clauses. But there are going to be responses to BEAT. There are going to be responses to FDII. There'll be responses to GILTI. And the question becomes, what do we do about those responses? Obviously, there have been an awful lot of interest in what the United States should do with respect to, for example, the state aid cases. And in 2016, spurred in part by Professor Grinberg's article on 891 and 896, there was a lot of interest in the code provisions that permit basically retaliatory taxation. When David referenced to me for the first time on the phone 891 and 896, I said, what are you talking about? 891 and 896? But they are very interesting provisions, still part of the code, and still potentially and a little bit of a case law on conflict and later in time as well, so it kind of wraps the panel, I think, all together. Still part of the code, still there's a question about how these provisions, one of which is almost 90 years old, another of which is 50 plus years old, interacts with our treaties and the principles that Mary just articulated. So 891, what is this provision? I'll read it out here. Some of you may be very well familiar with it. I was not. So the president, if the president finds under the laws of any foreign country, citizens or corporations of the United States are being subjected to discriminatory or extraterritorial taxes, the president shall proclaim basically that there's a problem and we're going to double the tax rates on each citizen and corporation. And that continues until the president so decides. Now, if we had more time, we could go more into the history. It's fascinating history. It was enacted as part of the 1934 Act, which was a major revision to the tax code. I put up here, this was from the New York Times, huge French levy laid on Americans. It was actually spurred as a result of the French imposing what it was essentially an attributed profits tax. They were taxing anybody who had a subsidiary in France. They would tax the entire worldwide profits, the worldwide groups. At least they were asserting it. And they called it was called the double taxation law. And they were asserting it against American companies in part, and they were asserting it for back taxes. And so the headline is $122 million, which ends up being $2.5 billion today, but a hefty sum. It was in the context of some trade negotiations, and also the parties had inked, France and the United States had inked a bilateral tax convention that eliminated double taxation and would have otherwise overrode this tax, but the French were dragging their heels. And so Section 891 was the brainchild of Fred Vinson when he was a congressman. Now, Fred Vinson would go on to become Treasury Secretary and Supreme Court Justice. And Fred Vinson thought of this provision effectively as the leveraging tool, the leverage tool, the ability to come to the bargaining table, in particular with France, frankly, to get the treaty ultimately signed, or at least to eliminate this taxation and this threat. And so the provision was enacted, and it gave an awful lot of discretion to the president, frankly, as the maker of treaties, gave the discretion to also double the tax rate. In this context, ultimately, the French relented. The law was abolished, and the treaty went through. And that provision has been on the books since the 34 Act, never been invoked in an operative way. We'll talk about some at least references to it by the Senate Finance as well as by Treasury more recently, but never been invoked. No regulations have been promulgated thereunder. The next provision is sort of a companion provision, but comes into effect in part of the Foreign Investors Tax Act of 1966, which is a grand liberalization, really, of our inbound taxation. It incorporated the ECI rules before there was essentially this super force of attraction. It gave the trading safe harbor. It put a cap on the rate on FDAP at 30%. For individuals, it could even have gone above 30% to the graduated rates. It was a real kind of revolution in our inbound taxation, but Congress was concerned that we gave away too much of the store. And so what they did in this provision was to basically say, look, if again, some similar type of grant of discretion by Congress to the president, if the president finds that citizens or domestic corporations are being subject to more burdensome taxes, then what we'll do is basically lift the Foreign Investor Tax Act, both rates as well as the substantive provisions, and go back to pre-1967 law. So screw me, screw you, basically, at the end of the day. And then there's a similar provision in terms of a higher effective rate, another discriminatory or more burdensome higher effective rate. Fine, you impose it on my people, I'm going to impose it on your people. It was a little tit for tat. What ultimately happened, again, and I'll get to the modern applications, there's never been an application. However, given the apparent focus on U.S. companies in the state aid cases, and in part spurred by, I think, some thinking in the academic community, there's been more interest. There was, especially in 2016, more interest in particularly 891, to some extent, lesser extent, 896. There have been some proposals to actually extend it to situations, for example, where we have 901J, which are the kind of the terrorist countries and similar blacklisted countries. And then it really came up in 2016. You had Senate Finance saying, hey, Treasury, do something about these state aid cases. Think about 891 and 896. And Treasury responded, yeah, well, we're thinking about 891 and 896. And again, there's some parallels back to 1933, where, again, this is more of a threat to bring people to the negotiating table, as I think was the original intent of these provisions. And this brings us now back, because nowadays, what do we have in the treaty? We have non-discrimination clauses, right? We have every modern treaty that we would care about as post-dating to these provisions, right? And we already went through a few of the provisions in the non-discrimination clauses or articles of our existing treaties from the US model. And obviously we have the subsidiary rule, we have the PE rule, we have the basic rule, which is the next slide here, which is, I picked out one treaty, but it's the same in the US model, which is the nationals, which is broadly construed to include basically anybody in the United States, shall not be subjected, or the other country, in the other contract, is saying to any taxation or any requirement connected therewith, which is other or more burdensome than the taxation and connected requirements to which the nationals of the other state in the same circumstance or may be subjected. And you say, well, hold on, David, that's a conflict, it seems. You have the president's the maker of treaties, right? And the president has made this treaty with his discretion, her discretion in mind. That president arguably is to waive that discretion under 891, 896. The president is the one that makes the treaties. It's obviously ratified ultimately by the Senate, but that's advise and consent. And so you say, okay, help me out here. I have the code on the one hand that permits discriminatory taxation. I have the treaty on the other that seems to preclude it, and the treaty is pretty clear on that in several instances. And the treaties are all later in time. If I would just go through that analysis, I'd say the treaty seems to be a significant problem, a barrier to the imposition or the invocation, I should say, of 891 and 896. Now, interestingly, with a couple minutes that we have left, there is a solution to that. Get the treaty out of the way. The president, our president now, has terminated several treaties. The president has the power in the Constitution to make it. He or she can unmake. He or she can suspend, maybe partially suspend as well. The Constitution would seem to permit it. The courts would probably call that non-justiciable. The Vienna Convention allows it. It's particular articles. Article 60, 65, there's a process if there's a material breach.
For a breach of a treaty.
For breach of a treaty provision, which it starts to become a big circle, right? Because I'm talking about a situation where the other side now
Have they breached the treaty?
has breached the non-discrimination clause by discriminating against our citizens. Of what paragraph? Of the non-discrimination clause.
What paragraph of the non-discrimination clause?
Well, it would depend on what the situation might be, but it could be any one of the multiple paragraphs.
If they had, sure, yeah.
I mean, I'm talking about what is odd here is, well, why isn't this all then part of the competent authority procedure, right? We have a treaty, we have a process in place. The Vienna Convention, I think, is probably the extreme answer at the end of the day in invoking and then sending a letter that, well, I'm sorry, you have materially breached the treaty. I'm now partially or fully suspending it. The Constitution would seem to permit that, but the treaty itself has a self-contained, almost arbitration provision would be the argument or one way to think about it. Any event, is this all going to happen? That's for all of us to see in the near future.
Yeah, we could take questions if anyone has comments or questions. We have a couple of them right here. Here we go. Yeah.
I'm just curious on the 891 hypothetical with respect to state aid, since the state aid mechanism would be, say, the EU ordering Luxembourg to collect additional taxes from a company in Luxembourg, would then the appropriate invocation of 891 be to then levy the retaliatory measures against citizens of Luxembourg?
Analytically, you would think so. It'd be difficult to talk about the European
Exactly. So it's just-
Union as a foreign
So
country.
Luxembourg is being forced by the EU to do something that Luxembourg doesn't want to do, and then we use 891 against citizens of Luxembourg.
What about the 27 or 8 EU countries that have signed up to the EU
Well, that's exactly the
instruments
question.
that
Do
have-
you
I mean,
do it
they're
on
all,
Luxembourg, or do you do
you
it
know,
on the EU-wide?
aiding and
basis?
abetting this? Come on.
That's fair.
We had another question? Yeah.
Yeah, thank you. Let's assume 7852D is unconstitutional and the court's applying traditional interpretation and trying to read the beat in harmony with existing treaties. The thing that I keep stumbling over is that there is sort of an override of treaties in the beat itself by way of, a somewhat oblique reference to 163J, which Professor Rosenblum referred to earlier. It explicitly treats you worse if you are a treaty benefit than it does if you are not and are subject to full U.S. withholding tax. Is that enough of an explicit statement of congressional intent to count for purpose of Supreme Court, or are we back to?
I personally don't think so. I mean, there's plenty of room for the beat to operate irrespective of that provision. In other words, you can easily envision, for example, foreign banks with PEs in the United States, which don't qualify for most of the non-discrimination rules, and therefore they aren't, for example, there's plenty of room that is not covered by the oblique reference to 163J where the beat could still operate. And I think we explain that, we say that in the article. That argument, it seems to me that is really a pretty tenuous argument because it clearly had nothing to do with any explicit desire to override the treaties. I mean, a court could latch onto it as a rationalization, I suppose. But it seems to me to be, I think it's pretty weak, personally. And what do you do with this straight out? I keep on coming back, because it's so much easier, to the straight out grant of a deemed paid credit for a taxable distribution. You don't have any help there at all. No, and that's just a flat out conflict, right? Or you could say, as Mary suggests, that no, it's not a conflict. We have a general rule. We have repealed 902. But we give a deemed paid credit for the first tier only by reason of the treaties. Where's the conflict? So, thank you. And thanks to the panelists. It's interesting.